everyone, Taylor Casper. I help parents make empowered choices with their finances so that if something were to happen to them, their minor children would still be well taken care of. I want to talk to you today about why you shouldn't name your minor children as beneficiaries of your life insurance, retirement accounts, investment accounts, or other similar types of assets. And in order to do that, I want to tell you what happens in reality if you name your minor children as beneficiaries of these types of accounts and then you pass away. So I've had the misfortune of dealing with this for a number of clients who are guardians and caretakers of minor children whose parents are now deceased. And what happens is you go to collect on the funds named for the minor child and they can't be released to you because minor children can't inherit money. They can't inherit houses, they can't inherit property, they can't take bank accounts, they can't take life insurance proceeds. None of those things can be passed to these children during their minority. And so what ends up happening is oftentimes you are required, whoever the caretaker of the minor child would be, or whoever the person managing finances for the minor child would be, has to go to the courts and petition the court for conservatorship of the minor child so that the funds can be dispersed in a conservatorship, basically in such a way that the guardian caretaker of this minor child and of this minor child's finances can manage these funds under court supervision. So the funds would get dispersed to the minor child's estate, and then the conservator would have to account for every dime that is withdrawn from the child's bank account and from the child's estate and spent on behalf of the child. So then at the end of each year, the conservator has to go before the court. They have to fill out paperwork and basically keep an accounting of everything they've spent, and then oftentimes appear and go before the court to have the accounting approved by the court, have the court say, yep, okay, you haven't misappropriated funds. And then when the child turns 18, the conservatorship terminates and whatever money is left just goes to that child outright. So there is potential for a lot of problems to arise with this setup for a number of reasons. One, what a headache and a hassle for the conservator to have to keep down to the penny records year over year, likely get audited, have to appear in court to make sure that this estate is, being managed on behalf of the minor child. And that's just a hardship and a headache for somebody that you probably really care about, if you that's probably taking good care of your child. So it's kind of a hardship and a headache for them to have to do that. It's not a quick and easy thing to have to do these accountings. If you mess them up, they can be frustrating. You're talking about people don't even balance checkbooks anymore. So now you're asking to balance every single penny that's spent over the course of the year. If the money's in investment accounts, you can't forget to account for the interest because you're going to be off 17 cents wondering what happened. So it's a lot to have a conservatorship and have to manage that money. I understand that they serve a good purpose. They make sure that funds aren't being misappropriated, but it's a headache and it's a hardship and it's a hassle. So that's a problem for a lot of people in and of itself. You're subject to court supervision and scrutiny. So just more than a lot of people would want to deal with. It makes it harder for a lot of people, especially trustworthy people, than it should be. The other issue, or the other thing that I think a lot of parents wouldn't be that excited about, is that at 18, on that child's 18th birthday, they have the right to petition to terminate this guardianship. They are no longer, petition to terminate the conservatorship. They no longer have to have financial management and financial oversight, and everything just gets turned over to them, and now they're the sole owner. I don't know about your child or my children, but I think a lot of 18-year-olds probably don't have the wherewithal to all of a sudden at 18 just be managing a large sum of money. It is hard enough for people who are in their 20s and 30s to get an unexpected windfall and then have to figure out what to do with it, let alone somebody who's 18, who doesn't have the lived experience, maybe doesn't have the financial literacy to be able to manage this money that all of a sudden has been dumped in their laps. We're talking about life insurance. A lot of people who are young carry, or should anyways, carry high levels of life insurance to make sure that children comfortably make it to the age of majority, that they make it to 18, not being in poverty or what have you. You're sustaining their life as they knew it, hopefully, if you were to die. And so you're talking about if somebody were to carry $1 million, $2 million in life insurance, I see clients all the time that have that level of life insurance because for them it makes sense, it's a good idea. Well, now at 18, what if there's $800,000 left over, $1 million left over, and it's just an 18-year-old's money? So that's probably not optimal, probably not what a lot of parents would want. So I've heard people or seen people take the workaround approach of, oh, I know that my minor child wouldn't ever be able to inherit a bunch of money from life insurance, retirement accounts, investment accounts, bank accounts, a house, what have you. So I will name my sister as the beneficiary or my dad as the beneficiary, and I'll just tell them that this money that I'm leaving to you is supposed to be for my child or my children or what have you. That is also probably not your best bet, because what happens in that situation is that, now sister is, just because you told sister that you want this to be used for your child, once that money is, that paperwork is filled out with the insurance company or the retirement company or the bank, that money goes to sister. She has no further legal obligation to pay for anything for your child. And you're gone, so you can't make her. And even for people that you really trust and are really trustworthy and who would want to do the right thing and would want to pay that money and use that money for the benefit of your child or children or what have you, there might be circumstances outside of your control and outside of their control. For example, if all that money gets left to a family member and that family member goes through a divorce, is subject to a lawsuit, gets in an accident, and now they have this money, that's going to be deemed their property, right? That is your money. That is what the law says. That's what the contract with the insurance company says. That is that person, whoever got it, regardless of the intention, it is that person's money. So if your sister that you left the money to because you wanted them to pay for things for your minor child gets in a car accident and is at fault and gets sued, that money can be attached to you by a judgment. So you don't have any safeguard from that. So that's also just not your best workaround. You don't want to leave it to your minor child, and you don't want to leave it to some other random adult and say, hey, use this for my minor child, because there are just so many facts and circumstances outside of your control, so many ways the court could get involved, so many things that could just go wrong because it's not the optimum setup. So, you really want to think about other avenues to make sure that your child inherits in a way where they can get the money according to your goals. And there are options. There are lots of options. There's wills, there's trusts, there's testamentary trusts, there's various types of accounts. There's all sorts of other things that you can really look at and think about critically before you make those two choices. So if you take away nothing today, just take away minor children don't inherit, they can't inherit, they shouldn't inherit, life insurance policies, 401ks, IRAs, SEPs, retirement accounts, investments, stocks, bonds, they cannot be the beneficiary because it's going to be either in a restricted account that's just going to sit there and nobody can touch it and nobody can use it till the child turns 18, at which point they get it all, or it's going to be subject to conservatorship and that court supervision, that annual accounting, that hardship and headache for whoever the conservator is. And you just really don't want to leave it to some other adult for the benefit of your child without the proper legal framework, like a trust, or the proper paperwork and documentation, likely with something like testamentary documents or trust, to make sure that that's getting done in a way that's going to achieve your goals and not be subject to whoever you left it to's life circumstances, like a divorce or a lawsuit or whatever, right? So again, Taylor Casper, owner, managing attorney of Legacy Estate Planning in Burnsville. If anything I said brings up questions for you, feel free to give me a call. Have a good one.